Legal Eagle is coming in loud and clear thanks to Ting Mobile. Before President Trump's photo op at St. John's Church in front of Lafayette Square, which resulted in peaceful protesters being gassed with chemicals and shot with rubber bullets, he appeared in the Rose Garden behind the White House to outline his response to the protests that have roiled this nation. President Trump threatened to take dramatic action to quell the protests, including invoking the Insurrection Act of 1807, which allegedly would allow him to deploy the military to crack down on protesters and rioters. President Trump did not officially invoke the Insurrection Act, but he did use his unique authority within the district to make a serious show of force. In recent days, for reasons that should be relatively obvious, people have debated how much authority the president has to use the military for civilian law enforcement purposes. And in addition to the Insurrection Act, you've probably heard people mention the Posse Comitatus Act and claim that the president actually doesn't have authority to invoke the armed forces in riots and protests. Well, I'm here to deliver the sobering news that the president actually has a lot of authority to use the military against the American people. But whether he can do it and whether he should do it are two completely separate issues. Hey Legal Eagles, it's time to think like a lawyer because I can personally confirm that there are a lot of American troops operating on American soil as we speak. And by the way, I started my research for this video by going to what I think is by far the best resource for national security law, and that's a blog called Lawfare. It's simply bar none the best resource for answers to national security law questions. You can go there at lawfareblog.com. I highly recommend it. So let's start with the Posse Comitatus Act. Does it stop the president from using the military domestically? Now, it's easy to confuse the Insurrection Act of 1807 with the Posse Comitatus Act. In fact, you'll often see people say that the PCA actually bars the president from using the military in domestic matters. And there's some truth to it, but it's largely false. Section 1385 of Title 18 of the U.S. Code states, "Whoever, except in cases under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army or Air Force as a posse comitatus or otherwise to execute the laws shall be fined under this title or imprisoned not more than 2 years or both." Now, a big part of a lawyer's job is analyzing the text of laws and judicial opinions, and you'll notice that this language provides a bar unless there is a specific act of Congress or something in the Constitution that allows it. And this is one of those situations where the exception predominates the rule. And generally, the Posse Comitatus Act prevents the military from participating in traditional law enforcement activities. However, Congress has enacted many, many exceptions to the PCA to allow the military to assist civilian law enforcement agencies in enforcing the laws. For example, the Department of Defense can provide some support to law enforcement agencies battling drug crimes and organized crime. The military may also defend their own bases and property. It's one of those instances where the exceptions tend to swallow the rule. It's kind of like the rule against hearsay. Sure, there's a general rule against hearsay being admissible in court, but frankly, there are so many different exceptions that it's actually the rarity where you can't get the hearsay admitted into court as evidence. But the biggest exception to the PCA is the Insurrection Act itself. So let's talk about that. The Insurrection Act of 1807 actually refers to 5 pieces of legislation that are found in 10 U.S.C. sections 251 through 255. The law sets forth several scenarios that a president may use to justify deploying the military domestically. Now, before the president can invoke the Insurrection Act, he, quote, must first issue a proclamation ordering the insurgents to disperse within a limited time. If the situation does not resolve itself, then the president may issue an executive order to send in troops. Now, it's important to note that the Insurrection Act actually dates back to a time when municipal police departments didn't really exist in this country, and so it made sense that there would be times when the federal government would need to send military personnel to help out with state or local issues. Now, given that in the modern era, every state and every municipality has a police department, one might question the utility of having the Insurrection Act remaining on the books. Now, the oldest section of this law is Section 254, which was enacted in 1792 to give George Washington authority to call forth the militia to repel invasions, suppress insurrections, or enforce the laws. Congress was initially reluctant to grant even Washington this authority, so they required that he would first need to give insurgents a warning to disperse. And although President Trump has explicitly threatened to invoke the Insurrection Act,
if a city or state refuses to take the actions that are necessary to defend the life and property of their residents, then I will deploy the United States military and quickly solve the problem for them.
To date, it's not clear that his speech qualifies as a proclamation required under this act. Section 251 of the Insurrection Act deals with federal aid for state governments. It combines two laws from the earliest days of the Republic. One was a law used to suppress the Whiskey Rebellion of 1794. This was an uprising of farmers and distillers who protested a federal whiskey tax. After years of protesters tarring and feathering tax collectors and destroying property, President Washington was given authority to call forth a militia upon the request of a governor or state legislature. The second part of this law was enacted in 1807 at the request of President Jefferson, and allows a president to call up a standing army as well as the militia. Which brings us to Section 252, which regards the use of militia and armed forces to enforce federal authority. Section 252 was enacted in 1861 at the request of President Lincoln to increase presidential authority to use the militia and regular army to suppress insurrections and enforce the laws. This law was the legal basis for waging the Civil War, and the law allows the president to use federal troops on his own initiative and act on his own judgment without having to wait for the request of a governor. And in fact, you're seeing a lot of governors on TV recently stating that they are not going to request federal troops or federal aid under the Insurrection Act. The thing is, for most of the Insurrection Act, it doesn't require gubernatorial approval. That brings us to Section 253, interference with state and federal law. In 1869, Congress added Section 253 at the request of President Grant to empower him to use federal troops to suppress the Ku Klux Klan during Reconstruction. Section 253 states, quote, "The President, by using the militia or the armed forces or both, or by any other means, shall take such measures as he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combination, or conspiracy, if it, 1, so hinders the execution of the laws of that state and of the United States within the state, that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and secured by law, and the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection, or 2, opposes or obstructs the execution of the laws of the United States, or impedes the course of justice under those laws." And you can tell by the plain text of this language that that is incredibly broad authority, and that in a situation where you have peaceful protesters and rioting and looting going on at the exact same time, that it's not surprising that someone might use the unlawful activity as a pretext to curtail the lawful activity as well. Now, originally, there were two fairly large limits on the use of military personnel by invoking the Insurrection Act by the president. The first was that the president had to get approval from a federal judge. The second was that the Insurrection Act could be used until Congress came back into session and then had to approve the use of the military. Now, those two restrictions on the Insurrection Act sunsetted out and no longer are part of the act and no longer act as a check against use of military personnel under the Insurrection Act. So when has the Insurrection Act exception been used to Posse Comitatus? Now, although the Insurrection Act has not been used frequently, presidents have invoked it to enforce the law, especially when racial equality is at stake. In 1957, President Eisenhower called on the U.S. Army's 101st Airborne Division to safely escort 9 black students into Little Rock Central High School after the Arkansas governor Orville Faubus had called on the Arkansas National Guard to stop the students from integrating the school. President Kennedy invoked the act in 1962 and 1963 to send federal troops to Mississippi and Alabama to enforce civil rights laws. In 1967, President Johnson sent the 82nd and 101st Airborne Divisions to Detroit to quell riots between police and residents after Martin Luther King Jr. was assassinated. And in 1992, President H.W. Bush responded to a request from Governor Pete Wilson of California to quell rioting in Los Angeles after the acquittal of the 4 LAPD officers who brutally beat Rodney King.
There are 3,000 National Guardsmen on duty in the city of Los Angeles, and let me assure you, I will use whatever force is necessary to restore order.
So in modern times, the presidential use of the Insurrection Act has generally been used to enforce civil rights and integration and racial equality rather than the opposite. And it's generally been used in ways that most people would find unobjectionable, at least in this day and age. And sometimes that use of the Insurrection Act was explicitly against the wishes of the state governors. For example, Governor Faubus had improperly used the state National Guard to disregard federal court orders regarding integration of students. And in that example, he certainly did not want the federal government's assistance. In fact, it ran completely contrary to what he wanted. Governor Wilson, on the other hand, did ask for help from President Bush. And the other instances also involved quelling of riots that were explicit responses to racial injustice. And there's probably one other historical example that is incredibly relevant, and that was the federal government's response to Hurricane Katrina. When the levees in Louisiana broke, the state and federal government were slow to respond to the enormous logistical challenges and humanitarian crisis. President Bush considered invoking the Insurrection Act, but the Department of Defense was concerned that Americans would be reluctant to see the military in that role. And at the time, the military was fighting two wars. And eventually, Congress amended the Insurrection Act to clarify the circumstances that would justify the use of armed forces. There is now language in the statute that lets the president use the military to restore order and enforce the federal laws if there is a natural disaster, epidemic, or terrorist act. Though ultimately the Bush administration decided not to invoke the Insurrection Act in support of humanitarian efforts regarding Katrina. And it's probably important to talk about the distinction between norms and laws. The law itself has been pretty broad for a very long time, but it's revealing that presidents have been reluctant to invoke the Insurrection Act. That is a presidential norm, a societal norm, but it is not written into the act. And you can see how a broadly written law that has been used in some instances where no one would object, and probably other instances that were closer to the margins, can be used for good and ill depending on who is upholding the norms and who is not. And the Katrina example is important because it reveals two concerns that normally come up when there's a situation requiring a national response. And that also involves the difference between norms and laws. First, the American people have traditionally been very wary about military operating on U.S. soil. This in turn has made the military wary of being deployed for civilian matters, and there are very good policy reasons that should probably be pretty obvious as to why you don't want a military doing law enforcement activity, and why you want a strong separation between a military that's trained to kill and a police force that is trained to serve and protect. And second, the Bush administration had a significant debate about whether to invoke the act. Members of Congress weighed in, and so did all 50 governors. Under normal administrations, both Democratic and Republican, there's a decision-making process where the president hears from stakeholders about the pros and cons of using the military. That doesn't mean the president lacks the power to use the military or enforce the law. On the contrary, the president clearly has the discretion to involve the military in civilian affairs under these different acts, even if the governors don't ask for help. But rather, it signals that, at least in modern times, we've had presidents who thought about what the governors might want, how the people might react, and whether a military response would actually make things worse. And it's hard not to think about the historical example of Caesar crossing the Rubicon, that sometimes the norms involving the lack of participation by the military in domestic affairs, or at least crossing the Rubicon into Rome, that norm exists for a very, very good reason. And it's also probably worth pointing out that the Posse Comitatus Act, in conjunction with the Insurrection Act, contemplate that the president is going to faithfully execute the laws, and that on that basis, the president probably has a lot of discretion to use the military to stop riots in the name of enforcing the laws, because we have a lot of laws out there. And it's hard to not think about this fact without examining the context of what actually happened when the president mentioned invoking the Insurrection Act, that while he was giving his speech in the Rose Garden, that he or Bill Barr gave orders to clear out the protesters in Lafayette Square so that the president could get his photo op at St. John's Church. To clear a path for the president's impromptu walk, the U.S. Federal Park Police used OC gas, pepper sprays, rubber bullets, and flashbangs on a crowd of peaceful protesters. All this happened before the 7 p.m. curfew. And of course, the right to protest, to peaceably assemble, is part of the First Amendment. This is part of the freedom of expression that all Americans enjoy. Protests are a way of life in Washington, D.C., which is to be expected. This is, after all, the seat of government. But it doesn't mean that President Trump's actions on Monday were necessarily illegal in the strictest sense. Over the last several decades, courts have allowed government to make more restrictions on the time, place, and manner of protests, as long as those restrictions are what's called content neutral. And you can imagine how some of these laws conflict with individual citizens' right to First Amendment activity, to petition the government, to peaceably assemble and to protest. There are, in fact, many statutes that make it clear that protesters cannot block access to federal buildings, or destroy private property, or stop the president from going somewhere he wants to go. But you can also imagine how some of these laws might be used as a pretext to quell First Amendment expressive activity. And one of the things that made President Trump's actions so incendiary is that he wasn't on his way to the Capitol to meet with Congress, nor was he doing anything strictly related to the business of being president. Instead, he just had an impromptu photo op that appears to be used for his re-election campaign that wasn't planned out and specifically conflicted with the protesters who were already there and were already protesting peaceably, using their First Amendment rights. But that's the difference between norms and things that are written into the law. And perhaps we've just been lucky that prior to now, we haven't had such a bumbling example of a pretext used to evacuate people exercising their First Amendment rights in front of the White House. And the same goes for the use of troops and military and federal officers throughout DC and the rest of the country. Even President Nixon never placed soldiers at the foot of the Lincoln Memorial, blocking the American people from accessing one of its most significant memorials, which we have seen that the Trump administration has done. And it's been a long time since all of Lafayette Square and such a significant portion of downtown Washington, D.C. has been completely locked off from protesters or even tourists. I participated in the Women's March in 2017. There were tens of thousands, if not hundreds of thousands of people who were allowed to walk right in front of the White House. And even that wouldn't be available based on what's going on right now. And in fact, in a direct historical parallel, when mass protests erupted after students were killed by the National Guard at Kent State University, then President Nixon left the White House and met with protesters personally at the Lincoln Memorial. This surreal event eventually led to Nixon creating a formal study of campus unrest during the Vietnam War. But because of Washington, D.C.'s unique position as a federal district rather than a state, and because of its disenfranchisement, the federal government has authority to use federal troops and military police officers in the limits of Washington, D.C. in a way that they actually can't do outside of the district. So if it sounds like President Trump has a lot of power, he does. Presidents in general have a lot of power to use the military for different ends. But as things stand, it's up in the air. It's not clear that the president has actually invoked the Insurrection Act. Secretary of Defense Mike Esper has voiced his opinion that the president should not, in fact, invoke the Insurrection Act and should refrain from using the U.S. military to conduct law enforcement and anti-riot actions.
The option to use active duty forces in a law enforcement role should only be used as a matter of last resort and only in the most urgent and dire of situations. We are not in one of those situations now.
So it's not clear how long he's going to be the Secretary of Defense, but you can imagine that if the Secretary of Defense is urging the president not to use troops in this context, that it's not surprising that people are going to protest the use of this kind of force, in addition to protesting the police brutality that we've seen throughout the country. But unfortunately, if you're out there protesting this use of the military and police brutality, there's a chance that you might be illegally arrested for your First Amendment activity. And if you are arrested and you need to make your one phone call to get your lawyer to get you out of jail, then at least you can use Ting Mobile and save some money. And as a bonus, the call with your civil rights lawyer will be super clear. God. Ting Mobile is a different kind of mobile provider. With Ting, you only pay for your actual data and services you use at the end of the month. And because you're paying for only what you actually use, Ting customers pay on average just $23 per month for one device. And Ting provides great LTE coverage because it uses the T-Mobile, Sprint, and the Verizon network. So you get the benefit of 3 massive networks wherever you go, which can be important when you've been unfairly detained in federal jail. And with Ting, you can use almost any cell phone, including the newest iPhones and Pixel phones, and you can use the same phone number you're using right now. There's no contract, overage fees, or any other carrier tricks. You just pay a fair price for the talk, text, and data that you use up every month. And Ting has award-winning customer service. Because they don't have any brick-and-mortar stores, they pour all of their resources into their phone and online support. If you have any issues, you can just give them a call and you'll immediately talk to a real human being. And they might be able to hook you up with a lawyer. With Ting, especially if you're around Wi-Fi all the time, which most of us are, considering we're working from home, I wonder if federal jails have Wi-Fi. You'll end up paying way less than you do now. Of course, some people should pay $200 a month for unlimited data if they're nowhere near their homes, but if you're surrounded by Wi-Fi all day long, you might be paying hundreds of dollars more completely unnecessarily. And Ting gives you the option to pay only for what you use. So if you go to legaleagle.ting.com, you can use your last bill to compare just how much you would save. And LegalEagles will get a $25 credit by going to legaleagle.ting.com that could cover your entire first month. And since there are no contracts, you can try it for a month, no strings attached. Again, all you have to do is click the link in the description or go to legaleagle.ting.com and get a $25 credit for whatever service you want. Plus, clicking on the link really helps out this channel. So, do you agree with my analysis? Do you think that we should amend the Posse Comitatus and Insurrection Act laws to make it harder to use troops on American soil? Leave your objections in the comments and check out this playlist with all of my other real law reviews talking about the crazy stuff happening with protests and COVID-19 and basically all of the news. There's a lot of it. So click on this playlist and I'll see you in court. Hopefully not literally.